سيدنا ونبينا محمد قائد الغر المحجلين وعلى آله وأصحابه وأتباعه إلى يوم الدين. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا بفيض فضلك رشدنا يا رب العالمين. Alhamdulillah, in our lessons on Maulana al-Imam Ibrahim al-Halabi's Multaqa al-Abhur, we have, by the grace of Allah subhanahu wa ta'ala, been looking at the section on Kafala, and now we get to the issue of Daman al-Darak, right, where there is a guarantee that is provided, right? So here this is where we have reached, right? If he proves walau barhana, so he says rahimahullah ta'ala, walau barhana ala anna lahu walau barhana anna lahu ala zaydin alfan وهذا كفيله بأمره قضي به يعني عليها. We've read that, correct? Bismillah. And then, so here, وضمان الدرك. بسم الله الرحمن الرحيم. So he says, وضمان الدرك للمشتري عند البائع يعني عند البيع تسليم. Right? ضمان الدرك للمشتري. ضمان الدرك itself, so ضمان الدرك, darak here refers to idrak, right? الدرك, that if, so the mushtari is paying a price to the buyer, that if something happens to the sale, the kafil is guaranteeing that the thaman will be returned to the mushtari, right? So he says وضمان الدرك للمشتري عند البيع تسليم, right? So this is a taslim, meaning it is a recognition of the sale, right, being legitimate, right? So, right, because why would you guarantee something? Because you're saying that this is a sound sale, right? It's a sound sale, right? So this is that if the Damanu Darak is that the third party, if it turns out to belong to somebody else, I guarantee that your price will be returned. So that's what the kafil is doing. Right? So the kafil, by doing this, is admitting to a few things. The guarantor is admitting that who owns the mabir? Who owns the mabir? The Sadati. Who owns the mabir? Originally? No, the seller, right? That before the sale takes place, the seller owns it. So it said, if it belongs to a third party, I will guarantee you the price. So he's admitting that it originally belonged to the ba'i'. And then after the sale, it legitimately would belong to the mushtari, right? So that's the role of the one who is a damin, the guarantor, in daman al-darak. Okay, so if this happens, then he tells us that if this is, so this is a recognition. Taslim, it's a taslim of what? It's a taslim of the sale being legitimate, right? فَتَبْطُلُ, right? In some copies there's a fa here, right? And others there isn't. يَبْطُلُ دَعْوَى الضَّامِنْ الْمَبِيعَ بَعْدَ ذَلك. Right? So after this, if the damin, the guarantor, who's the kafil, right, says, actually, the item of sale belongs to me, this would be rejected, right? Because if you remember, in the claim section, we took an associated principle, right? About tanaqud. Anyone recall it? Right? A principle related to milk and claims. So the principle said that and these principles are important to retain, that التناقض ينفي دعوى الملك. Right? So you, by saying you're guaranteeing the price if it ends up belonging to a third party, and then you say it actually belongs to me. So التناقض ينفي دعوى الملك. Right? واضح? And there's another broader principle that this relates to, which is that من سعى في نقض ما تم من جهته فسعيه مردود عليه. من سعى في نقض ما تم من جهته. Whoever takes the steps to negate a matter that was completed from their side, this is rejected from them. So you said, yes, it belongs to the seller, and then say, no, it belonged to me. And you guarantee that it belonged to the seller, this would not be accepted. So this is the issue of ضمان الدرك. واضح سادتي before we proceed? Confirmation?
Yes.
Alhamdulillah. Right? تماما. Right, so this is ضمان الدرك, and more discussion on ضمان الدرك is forthcoming. And he says, وكذا لو كتب وكذا يعني كذا أي تبطل دعواه, his claim would be rejected. Like وكذا لو right, sorry, my screen is a little bit messy. وكذا لو كتب شهادته وختم على صك كتب فيه باع ملكه أو بيعا باتا. Likewise, if he لو كتب, likewise, if he writes a witness, and who? The one guaranteeing, right? So this person who's acting like a guarantor, he writes a witness that this belongs to the seller. وكذا لو كتب هذا الضامن, right? Likewise, this person guaranteeing, it bears witness, and they sign, so in an official capacity, and official capacity that would be recognized in court. He said, I confirm that this belongs to the seller. And then what does he do after that? He says, no, it actually belongs to me. In court, legally, etc., this would be rejected for the same reason, right? Right? Because تناقض ينفي دعوة الملك تماما, right? And he says وكذا لو كتبها, right? So وبخلاف ما لو كتبها على إقرار العاقدين, as opposed to if all you're doing is you're confirming that the two parties state such and such, right? You say, I can confirm that Zubair sold this to Zubaydah. Are you confirming that Zubair owns it?
Not necessarily.
No, right? So that's the difference between these two issues, right? And we ultimately have to see what's the substance of what he confirmed, basically. Right? We see what's the substance of what he has confirmed. So this is the acknowledgement of ownership in these scenarios. And وضمان الوكيل بالبيع الثمن للموكل باطل. Right? ضمان الوكيل. Right? وضمان الوكيل بالبيع الثمن للموكل باطل. So here, how do we decipher these things, Sadati? We have to say, okay, who are the transacting parties? Who's this person, a wakil, on behalf of? Right? So we parse this. ضمان الوكيل بالبيع. So الثمن للموكل. So they're acting as a wakil here on behalf of whom? Sadati?
Buyer?
الضمان الوكيل بالبيع. So they're being ضمان الوكيل بالبيع. Right?
Oh,
Right? So there's a very... Okay. Can you explain, Sidi? So the ضمان, right? This is explained by Sheikh Zada. He says, يعني إذا باع رجل لرجل ثوبا بأمره. Right? ثم ضمن الثمن عن المشتري للآمر لا يصح. Right? So the wakil sells the garment, right, on behalf of the owner. Right? So the wakil sells the garment on behalf of its owner. And then he guarantees payment, right, from the muwakkil, right? The selling agent can't guarantee the price. Why? Because it's a conflict of interest. If you're wakil on behalf of the seller, you are morally bound to take care of the interest of the seller. Correct?
yeah.
And then you say, I will guarantee the price for the other party. This is batil, right? Because there's a conflict of interest. وكذا ضمان المضارب الثمن لرب المال. Right? This is also batil. And the explanation is يعني إذا باع المضارب مال المضاربة. So the مضارب is the working partner in عقد المضاربة. Right? There's the رب المال, the one who puts up the capital, and you have the مضارب, who is the working partner in a مضاربة. Right? So now he says, I will guarantee payment on behalf of the buyer. You can't. Right? Because the kafala, right, is, here there would be a conflict of interest because you cannot be a guarantor and the one who is demanded from at the same time. Right? Because in tawkil, who is the aqd ascribed to first? Like when the wakil buys, who is the contract ascribed to first? If a wakil buys or sells, to the wakil, right? And in the mudaraba, the mudarib is acting as a wakil on behalf of whom? In any partnership, the partners act as wukala on behalf of each other, correct?
Yes.
Yeah. So then you cannot be wakil on behalf of, so the mudarib cannot be de facto when he sells the subject matter of the mudaraba, he's acting as a wakil for Rabb al-Mal. And then he said, okay, and I will be the guarantor for the buyer. So you cannot be the one who takes both sides of a financial contract, right? Because there's an inherent conflict of interest, right? And so in financial contracts, you cannot you cannot, conflict of interest is not accepted in financial contracts, right? Unless there's explicit permission, etc. That's a separate thing. So as opposed to marriage, because if the wakil, so for example, it happened to a friend of mine. I met him recently. He was overseas, and his wife was in his future wife was in the US. When the wakil conducts the marriage, is the marriage ascribed to him first, and then to the guy marrying? No.
No.
It's immediately ascribed to him, right? So there, a wakil can act on behalf of both parties in a marriage contract. But in a financial contracts, where the huquq of the aqd, who do they return to? Initially, to the wakil, right? So, if I go to Istanbul and Sidi Masir says, can you buy me such and such book? I agree to be his wakil. And when I buy the book, I take the book, say, okay, where's the payment? So ask Masir Ali, this is his email. Unless the guy agrees, say, no, you cannot leave the bookstore until you pay me. Even though I'm the wakil on behalf of Sidi Masir, right? The mutalaba in the aqd goes to the wakil first, and then it goes back to the asil. واضح? So this is the issue of the wakil cannot, you cannot be a guarantor for the other party. You can put in a good word or whatever. وكذا, right? وضمان أحد الشريكين حصة شريكه من ثمن ما باعه صفقة واحدة. Right? Likewise, for one party, for one partner to guarantee the other owner's share of a single transaction is not valid. Why? Because if you're guaranteeing that, what happens? So this scenario is if two people who are in partnership sell a garment to a third party in one transaction. Okay, so safqa wahida. And one says, okay, I'll be a guarantor. So there are two partners. Zubayr and Zubaydah started a company, ZZ. ZZ Thobes. Right? So Zubayr says, I will guarantee your side of the payment. This is not valid because he will be guaranteeing his own share in that, right? So that would again be an inherent conflict of interest, right? So a co-owner cannot guarantee their partner's share if it's in a single transaction. وصح لو بصفقتين. But if there's multiple parts, he can guarantee his partner's share of the payment because the payment is due to both of them, right? The payment is due to both of them. So in the first scenario, it's as if you're guaranteeing for yourself. But if it's 50% and there's sale of two distinct things, say, okay, this is from my share, that's from your share, so I'll guarantee your share, right? But you cannot guarantee the share before it has been apportioned. Tamaman. So this is, and why? Because of the conflict of interest entail. Because it's as if you're guaranteeing for yourself, or in the other case, acting with conflict of interest, right? Then the issue of ضمان الدرك وضمان الدرك والخراج والقسمة صحيح, right? ضمان الدرك, so a guarantee, right? Guaranteeing ownership from third-party claims is valid. And we explained it a little before. It could have been better to mention earlier. So ضمان الدرك is valid. And someone can guarantee that if the item of sale ends up belonging to a third party, I guarantee that your payment will be returned. Today I purchased something from Indonesia. I was looking for a bag for somebody and discovered that it's actually remarkably good bags at an international quality in Indonesia. So I ordered a bag from Indonesia. I was a bit reluctant, but I read reviews. It's very good. But let's say I didn't know that if I buy a bag from these guys, will they actually deliver it? So So let's say I had an Indonesian friend. This didn't happen, but let's say they said, okay, see Faraz, if you buy from this company, I'm not going to mention its name, if they don't deliver it or they disappear on you, I will guarantee the return of your price. So I said, okay, cool. I trust you more than I trust them. So I enter in the transaction. This is Daman al-Darak. And we've talked about it. It's valid. Daman al-Darak wal-Kharaj is to guarantee the Kharaj payment. When it becomes due, right? Said, okay, I will guarantee that if they don't pay, I will pay. Right? So this is valid to guarantee. وَضَمَانُ الْقِسْمَةِ, right? And they differed what ضَمَانُ الْقِسْمَةِ refers to, right? Right? And this is with respect to shares, right? So, like shares of ownership, right? That, okay, so you enter into a partnership with someone over a house, right? So when the house will be sold, how do I guarantee that I will get payment for my share of when the house is sold? Now, the price would have to be split between us, correct? So I said, okay, when the sale price is apportioned, if they don't pay you your share, I will pay it. Right? That is ضَمَانُ الْقِسْمَةِ. Right? That qisma, and there's of course a section that comes in qisma, that when something is apportioned, this is how we will split it. Okay. Tamaman. Is the question related to the text itself? Go ahead. Someone has their hand up.
I'm enjoying the lecture actually, but I'm thinking if probably after every classes, you can send us a PDF. We
Yeah,
can
so if you
always get
register in the,
access
if
to
you
because
know,
of-
so if you enroll in the class, the class has all the slides there. Inshallah, see Abdul Latif, you can just pull.
I only
you can,
get
Yeah.
I only get mails to log into class. I don't know if there is any other places or platform I could get access to the slides.
Yeah, so the slides are all in the course page. Inshallah. See Abdul Latif, just share the link, inshallah. Jazakallah khair. Okay, so we'll proceed because there's a lot to cover today. He says, وكذا ضمان النوائب سواء كانت بحق ككري النهر وأجرة الحارس أو بغير الحق كالجبايات. Right? So he says, and this is one of the positions, right? That guarantee for the word nawaib itself is the plural of naiba, which is that which occurs, al-haditha. But this is a terminology. The nawaib are the things that the ruler charges, right? So they're like levies or taxes, right? So guaranteeing someone's payment of taxes is valid. And there are two types of taxes that can be imposed, right, by the ruler, whether they be rightful taxes, right, like or tax or a levy, right, like kari al-nahar, that they charge for the costs of, on agricultural lands, for example. The government has taken on that we will take care of keeping the rivers, walled and flowing, etc. وَأُجْرَةِ الْحَارِسِ. So there's guards and the other essential services that the government provides. Those taxes are valid, right? And for the costs of the police, etc. But the basis is that كل المسلم على المسلم حرام. That everything of a Muslim is inviolable for another Muslim, whether an individual or the government. دمه وماله وعرضه. And that includes your property, right? Sometimes we are very conditioned. Taxes are a modern phenomenon that is not in itself permissible, right? So that's one thing. So that's what raises the issue. So guaranteeing the tax or levy that is due on somebody is valid, whether before it is due on them or after it's due. So then, someone comes and says, I can't pay. So it's okay, well, you can't pay, we're going to detain you. Say, no, listen, give them some time. I will guarantee that tax. That if he doesn't pay, I'll pay it. Don't jail him, don't beat him up, whatever. Right? So that is valid. Whether these be, these nawa'ib, these government levies and taxes, whether they're bihaq, rightful, or bighayri haq, right? And these are like the jibayat. And what are the jibayat, right? Which are taxes that are not justifiable, right? Because the rulers would take money and they're not for very specific things, right? Because they lavish things, etc. So can you guarantee those kinds of taxes? So many of the ulama said, no, you can't. But the fatwa is that even those can be guaranteed, right? Why? Because ultimately the ruler is going to demand that from you. And then between you and Allah subhanahu wa ta'ala, it's, the person, right? Because if you're stuck having to pay it, is there mutalaba in the dunya for that wrongful tax? Yes. Because generally the qadi is going to stand with whom? With the ruler. They should stand for what is right, but generally, whoever rules the lands, influences the judges. And that's just a reality. So the fatwa is on what's in the text, that you can guarantee a tax or a levy, whether it be a rightful tax or a levy, like the first case, the Kadi al-Nahar, etc., or bighayri haq, like just the government randomly charging different matters. Okay. And there's a definition of Daman al-Darak from Multaqa al-Abhur, right? Which, that comes from what's earlier. Just wanted to share it. Multaqa al-Abhur is one of the commentaries, is by Wahdati Effendi. It's one of the commentaries on Multaqa al-Abhur. It's available only at present in manuscript form. I think the first part of it may have been published quite a while back in an old edition. Anyways, so that's the definition there. You can take it from the slides later, but we explained it out. Tamaman. And so we also shared the issue of Daman al-Darak. There's an explanation from Imam Nasafi. This is from Al-Kafi fi Sharh al-Wafi, which is a very great book. The Wafi, what is the famous book of Imam Nasafi's, from which that Al-Wafi is the origin of?
The Kanz.
The Kanz, right? So Imam Hafiz al-Din Nasafi was going to, he wanted to write a commentary on the Hidayah. But he had a dream that this is not befitting you. And of course, between him and Sahib al-Hidayah, I believe there's only one person. Imam Hamid al-Din al-Darir. We can double check. Maybe two, but I think the closest chain is one person. Hamid al-Din al-Darir to Sahib al-Hidayah. So he said, rather write your own book that's like the Hidayah and then comment upon it. So he wrote the Wafi and then he commented upon it in a great sharh called Al-Kafi. And see, Abdul Latif, remind me, I'll share the closing part of it because the lament from Imam al-Nasafi that he regrets that a lot of people won't truly benefit from this work. But this is a very useful explanation of Daman al-Darak. It's a wonderful commentary and it's quoted a lot by Ibn Abdeen and others, Sahib al-Bahar, etc. Okay. And then there are, we can basically look at the valid types of Daman and their reasoning, right? So you can review this from the slides, right? That they're valid and this is why they're valid. And then we can look at invalid guarantees and why. Other invalid guarantees include, say, وَضَمَانُ الْعُهْدَةِ بَاطِل. ضَمَانُ الْعُهْدَةِ, right? That al-uhda is like, this is unclear what exactly is being guaranteed. Al-uhda can either refer to a type of, it's like say, I guarantee his commitments. Right? Now, it used to be used, so where it's clearly known what it's referring to, then we'd assess, is this something that is due or not? Right? Because I guarantee his commitments. Which commitments, right? It also can refer to his contracts, what are due upon them. Uhda can also refer to khiyar al-shart. So it had different meanings. So you cannot guarantee something that is vague and unclear, such that it would lead to dispute. So that's the issue of Daman al-Uhda. Then he says, وَكَذَا ضَمَانُ الْخَلَاصِ خِلَافًا لَهُمَا. Right? That likewise, ضَمَانُ الْخَلَاصِ, right? That it's a guarantee that you'll maintain ownership of something if it turns out to belong to a third party. So this is that, okay, for example, someone buys a fancy new bag, a fancy leather bag from an antique leather bag. Okay? Now it turns out, so someone says, I'll give Daman al-Khalas, that if this bag turns out to belong to a third party, I will free it from their ownership and make sure it comes back to you. Is this something that you can successfully guarantee? Is this something you can successfully guarantee? Right, so the scenario is that you guarantee that if this bag that you purchased ends up belonging to someone else, I guarantee that I will compensate them and get the bag back to you. Is that something you can successfully guarantee?
No, it belongs to someone else.
Yeah, they may not agree to sell it to you. Right? So this is why the position that, right? So, this is what I explained was Abu Hanifa's position, right? In the sense that what it's referring to is that you will acquire the bag from the third party and give it back to the owner. You give it back to the buyer. The Sahibain defined it in a manner that's basically akin to Daman al-Darak. The Daman al-Takhliyas, the that the guarantee of freeing the item, what does it refer to? It simply refers to that if the item ends up belonging to somebody else, I will pay you back for it. Right? I will guarantee the price, because you cannot guarantee the item itself. That's what Abu Hanifa deemed invalid. What the Sahibain considered Damanul Khalas, that if the bag belongs to a third party, I will return the price to you. That is Daman al-Darak, right? واضح? So the khilaf is not, on this understanding, the khilaf is not haqiqi. Right? The khilaf is lafzi. Right? It's based on a different interpretation of ad-darak. And then of khalas, afwan. Tamaman. That's why we put difference opinion. And he says, وَلَوْ قَالَ الْكَفِيلِ ضَمِنْتُهُ إِلَى شَهْرٍ وَقَالَ الطَّالِبِ بَلْ حَالًا فَالْقَوْلُ لِلْكَفِيلِ. Right? If the guarantor says, I guaranteed it being, payable in a month, right? And the talib, the one owed the money, said, no, you guaranteed it being due now. فَالْقَوْلُ لِلْكَفِيلِ. Right? The guarantor's word is taken because the asl is, this is if the one who owes does not have proof, right? Because al-asl and al-qawla lil-munkir, right? Al-bayyinatu ala al-mudda'i, the one making a claim, and who's claiming immediate payment here? Who's claiming immediate payment?
The seller or the
the seller, right? The creditor, the one owed money, he's saying, no, it's due now, right? And in general, al-qawlu lil-munkir, right? So this is in the absence of proof, and that's why you guarantee everything, right? And وَفِي الْإِقْرَارِ لِلْمُقِرِّ لَهُ. And in admission, في الإقرار القول للمقر له. And in an admission, the word of the one you're admitting for is accepted. Because the default is that the person admitting, how much would they admit? Would you admit to owe more or less?
As little as they can.
Yeah, so the one admitting, the muqir, would admit to the lesser amount. The muqar lahu, the one you're admitting to, if they disagree with you, they would expect more. واضح? So, the one you're admitting for is denying your admission, because he says, no, it's more. So his word is taken, right? Because al-qawlu lil-munkir. Of course, they also have to make a yameen. Right? Right? And the one making an admission would have to prove that it's only the lesser amount. Tamaman. Then we have one other issue in this section, which is ولا يُخَذْ ضمان الدرك إن استحق المبيع ما لم يقضى بثمنه على بائعه. In the case of the ضمان الدرك, if the item of sale ends up belonging to a third party, right? You don't have to compensate the one you guaranteed for unless there's qada to prove that it belongs to that other party, to the third party. This is qada'an. Like someone can't force you to guarantee in the situation of Daman al-Darak unless it's proven in court. Right? Because you are not a transacting party. If one person says, yes, it actually belonged to so-and-so, because they could be cheating you. Right? They could be, there's a seller, the buyer, and the third party. You're the guarantor is outside this transaction. You just guaranteed the price. But they could have ganged up on you. So unless in court this has all been verified, it's not in dunyawi terms due upon you. بِالضَّمَانِ الدَّرَكِ. However, morally, if everything appears to be correct, it would be due upon you. And morally. But qada'an, it's not enforceable against you unless it has been proven in court, right? So, so morally, you have a right to check. You have a right to check that, that I want to see documentation of every step. If they provide you all the documentation, etc., then you say, okay, I will pay my daman al-darak, right? The guaranteeing of the price, right? So, because otherwise it's just claims and people, so the guarantor, usually a guarantor would be wealthy or poor.
Wealthy to guarantee.
Yeah, exactly. So the buyer and seller could kind of trick the goodwill of someone who's well off. Yeah, he's well off, well enough. So what do? Say, look, we'll claim it belonged to that third party. And so the three of them, buyer, seller, and the third party, take advantage of the goodwill of the guarantor. And then the buyer, the mushtari, for whom you guaranteed the price, after this, what happens? He disappears out of town. He could be from another city. Right? So people do this kind of stuff. So unless it's been proven in court, the right of the guarantor here, because the guarantor is not a direct party, right? And do you have to take the effort to verify claims, etc.? No, right? So that's why daman al-darak it's a good idea, but one has to be aware of the realities of people as well. Okay. Then we have this section on mutual guarantee. كفالة الرجلين. So he says, rahimahullah ta'ala, right, that دين عليهما كفل كل واحد عن صاحبه, right? If they're two debtors and they guarantee for each other, right? فما أداه أحدهما لا يرجع به على الآخر إلا إذا زاد على النصف, right? So there's a debt owed to two people, right? So they together sold their house. So they both owed the house 50%, right? Daynun alayhima. So they're owed the payment of the house. So they purchased a house together. Zubayr and Zubaydah purchased a house together. So they owe $100,000 for a house that they purchased, right? For a house that they purchased. I'm going to stop it otherwise. Keep writing. Okay. So they bought a house together for $100,000. So each owes $50,000, correct? So Zubayr decides to start repaying. So he pays $25,000. Can he demand half of that from Zubaydah? No. Because he owes $50,000 of it. So if a debt owed by two parties to another, Zubayr and Zubaydah bought this house together, they owe $100,000. Until he's paid more than $50,000, he's paying his part of the debt. Right? This should be pretty clear. So that's the mutual guarantee, right? Because each partner, is guaranteeing on behalf of the other, so to speak. ولو كفلا بمال عن رجل وكفل كل منهم عن صاحبه فما أداه رجع بنصفه على شريكه أو بكله على الأصيل لو بأمره. If both guaranteed for a third party, each guarantees for another. Right? So two individuals say, we both guarantee this debt. It's valid. So if one pays for it if it's with the command of the one owed the money, right? They're co-guaranteeing. So in this situation, right, whatever one party pays, half is owed by the other guarantor. And they both can go back to the asil, the one who originally owes the money. واضح? So this is not so, because kafala is itself not that common. This is even more rare. وإن أبرأ الطالب أحدهما فله أخذ الآخر بكله. And if the talib, the one owed the money, absolves one of the guarantors, then the other guarantor can still be demanded from. Right? So Zubair wanted to buy the house and he provided 2 guarantors. But then Zubaydah realized one of the guarantors is my dad. Is she going to demand the money from her dad? She's scared of Uncle Jamil. So she said, Dad, please stay out of this. This is between Zubair and me. So she absolves him, but so then one guarantor remains. Right? فَلَوْ أَخْذُ الْآخَرْ بِكُلِّهِ. Right? So this is the scenario there. ولو فسخت المفاوضة فلرب الدين أخذ يعني من شاء من شريكيها بكل دينه. So if you remember, there's different types of sharika. The comprehensive partnership where people become partners in all their property, this is called sharikatul mufawada. Right? It's a complete partnership. This would happen amongst immediate family members and others. Right? So in that case, if that is dissolved, then the one who is owed the money, the creditor, can demand from each partner. وما أداه أحدهما لا يرجع به على الآخر ما لم يزد على النصف. And then what one paid of the debt, he cannot demand it from the other until it goes beyond half, i.e. beyond his share of the money owed. Right? This is sharikat al-mufawada. And then the contract of manumission. ولو كتب العبدان بعقد واحد وكفل كل عن صاحبه رجع كل على الآخر بنصف ما أدى. Right? So we're not, these you can read the reasoning yourself because these are not common in our times. وإن أعتق السيد أحدهما قبل الأداء صح. Right? This is in the case of the two abds having manumission. وله أن يأخذ حصة الآخر منه أصالة أو من المعتق كفالة. Right? So this relates to the contracts of manumission. You can read the details. We've translated in the slides. We're not going to go. And you can, and in terms of guarantees for the bondservant, ولو كان على العبد مال لا يجب عليه إلا بعد عتقه فكفل به رجل كفالة مطلقة لزم الكفيل حالا. Right? So if the debt is not due till the freedom of the slave and the guarantee is unspecified, it's due upon the guarantor up front. وإذا أدى لا يرجع على العبد إلا بعد عتقه. But then the guarantor cannot demand it from the slave except after they're free. ولو ادعى رقبة عبد فكفل به رجل فمات العبد فبرهن المدعي أنه له من الكفيل يعني قيمته. Right? So you can read that masala as well. There's a whole bunch of Because this is one of the things that would happen, that, people would want their slaves, they would enter into contracts with their slaves that if you pay up, you'll be free. But what would be the problem? Slaves are weak, right? That they're trying to work, etc. They don't have enough capital. Say al-abd al-ma'zun bit-tijara, for example, that you can work, earn, but the likelihood of them not paying up. So someone who likes the slave becomes a guarantor. That we'll pay up, etc. So what would happen? Lots of issues would arise because it's not a practical thing. We're not going to go into the details of these, right? ولو كفل سيد عن عبده بأمره أو عن عبد غيره أو عن عبد غير مديون عن سيده فعتق فأي أدى لا يرجع على الآخر. And you can read the reasoning. These we wanted to deal with. In the final part, بإذن الله تعالى, which we'll take on Wednesday, we'll look at the issue of hawala. Of hawala, so that's the next part coming up. This is debt transfers and related issues. This is a relatively short section, after which we will start qada. Any questions, Sadati? So I apologize if you're fascinated by the issues of abid, but the underlying principles are that the abd is considered ajiz. So, how can you make mutalaba of them? But the debt is owed, correct? The debt is owed. So can you demand from the ajiz? No. But the kafil, are they ajiz?
No.
No. So they could be demanded from, right? That's sort of the key concept to understand. I didn't want to go into the details of it. We're going to look at hawala next. It's a reasonably short section. Right? So hawala, right? So we'll tackle it. I forgot we started late. So hawala, right? The key concept in hawala is that kafala is dammu dhimmatin ila dhimma, right? Is adding one person. There's the one who owes the money, and you have the guarantor. So the one who's owed the money can demand it from the asil and from the kafil, correct? Whereas in a hawala, what happens is naqlu dhimmatin ila dhimmatin, right? Here, you transfer the debt from the one who owes the money to the one it's transferred to, right? So there's one person called the muhil. Right? This is the one who's transferring the debt. And then you have the one who takes on the debt. What are they called? They're called the muhal alayhi, right? The one who takes on the debt. So there's the debt transfer, there's one who transfers the debt, and there's one the debt is transferred to. So for example, Zubair purchased the house for $100,000. Zubaydah then encouraged him to dedicate himself to talab al-ilm. Now he doesn't have, he's not able to pay. But Zubaydah is a really pious lady. Okay. She's a really pious lady, so she doesn't want Zubayr to worry about the debt. So what does she do? She says, okay, I'll take on the debt. So who is the muhil here? Who's the muhil? So Zubayr had purchased the house, and then Zubaydah, so he owes the money, then Zubaydah had the debt transferred to her. So who's the muhil?
Zubaydah.
No, the muhil is the one who's transferring the debt. who is it? The one who's transferring the debt is Zubair, right? He owes the money. So he's transferring the debt. The muhal alayhi is the one who takes on the debt, which is, in our case, so Zubair bought the house for 100,000. So he owes the money. So he's the one transferring the debt to Zubaydah. So he is the muhil, she's the muhal alayhi. Well, the muhal alayha, but let's call her muhal alayhi, right? And the one owed the money is the muhtal. Because he may not accept. Like someone agreed to sell the house to Zubair, right? So he's expecting payment from Zubair. Can Zubair just say, no, don't ask me. It's my wife who owes the money. Right? So you'll see that whose approval is required is one of the important issues in debt transfer. Okay, so keep that in mind as we look at this. Right? And later we'll also look at the issue of suftuja, right? A traveler's loan to ensure safety. So he says, rahimahullah, Kitab al-Hawala. هي نقل الدين من ذمة إلى ذمة. Right? It is a transfer of debt from one person to another. وتصح في الدين لا في العين. It is debt transfer is valid in debt. It is not valid in property. One more. Right? It's not valid in property. You can't say that, okay, don't ask me for the item of sale, ask so and so. Right? Right? So it's valid in debts, not in properties. Okay. برضا المحتال, with the approval, this is a key condition. Who is the muhtal? With the approval of the muhtal and the muhtal alayhi. It requires the permission of two key parties. Number one, the creditor. Who is the muhtal, Sadati? The creditor and the one who, and the debt, and the one, and the muhtal alayhi, right? That I'm transferring the debt to Zubaydah. She has to agree, right? Just imagine if Zubayr could say, Khalas, I don't owe it, my wife owes it. She has to agree. And the one who's owed the money, that's the muhtal, right? The one who's owed the money, for whom, because all this debt transfer is taking place. Because Zubair can't pay, so, or for whatever reason, Zubair's hospitalized. It could be many things, right? So these key terms are important to be very clear of, right? The muhil, the muhtal alayhi, right? So the muhtam, and so the muhtal is the one who's owed the money, right? The creditor, the one who is owed the money. The muhtal alayhi is the one whom the debt is being transferred to, right? The one who the debt is being transferred to, the transferee, but the one to whom the debt is being transferred. So these are the two for whose permission is definitely required. وَقِيلَ لَا بُدَّ مِنْ رِضَى الْمُحِيلِ أَيْضًا. And it is said that the permission of the one who owes the debt, the debt transferer, is also required. In our case, Zubair, right? And the chosen position, as indicated by the text, that this is not required. Right? Why? Because someone could take on, look, they don't owe the money, I will take it on, and the two parties agree, right? And it's best that they document this, right? But once that happens, diyanatan, right, there's consequences. If, Uncle Latif, if you sold the house to Zubair, and then Zubaydah comes and says, look, my husband is a student of knowledge, etc. Please transfer the debt to me. I will pay you. And you agreed. Can you now demand the money from Zubair?
No.
You can't. Now, if it was unbeknownst to Zubair, right, which is possible, you have to be upfront. Morally, you cannot accept it from Zubair and then go and demand it from Zubaydah as well. Right? That would be, that would be أكل مال الناس بالباطل. Right? So, if this debt transfer happens with the approval of al-muhtal, which is the one who's owed the money, and the approval of al-muhal alayhi, which is the one who takes on the debt, the one who the debt is transferred to, that is al-muhal alayhi. And it helps to think of muhal alayhi, the one who the debt falls upon. The muhil is the one who transfers the debt. Normally, someone would transfer the debt to another, but it's possible that the one who takes on the debt would just voluntarily take it on. Now, if you voluntarily took it on as a hawala, then khalas, is this just tabarru'? Is this just like a promise?
No, it's an obligation.
It becomes an obligation, right? So the tricky thing that comes up is sometimes a hawala, was it really a hawala or it was just a promise? Right? The Zubaydah says, Uncle Latif, she calls you Ammu Latif, if my husband, don't ask my husband, just ask me. What is that? It gets tricky, right? It gets tricky. So, إلا أن تكون تجارة عن تراض منكم. It should be clear. It should be explicit. Should be in writing. Right? So that it does not lead to dispute. تماما. So then he says, right? So the rida of the muhil, the one who's owed the money, is not required, right? That's what the author went on, and that's what the commentators followed as well. وإذا تمت أي الحوالة برئ المحيل بالقبول. If the hawala is complete, right, which is bi-ijab and qabul, right, by offer and acceptance, or that which takes place between the one who owed the money and the one who is now taking on the debt, then the one who originally owed it is absolved upon the acceptance. فلا يأخذ المحتال من تركته. Therefore, the one owed the money, the muhtal, cannot demand the money from the tarika, from the estate of the one who originally owed the money. In our case, Zubair. Zubair bought the house for 100,000. Zubair dies. He had a heart attack when he realized that he doesn't owe the money for the house. He was so happy, he fell off the balcony and died. He left money in his estate. This debt would not be taken from the estate because who owes it right now? Who owes it? Zubaydah owes it. In our example, right? The muhal alayhi owes the debt. Agreed? So it's not taken from the estate of the one who originally owed it. لكن يأخذ كفيلا من الورثة أو الغرماء مخافة التوى. Right? However, the creditor has the right. لكن يأخذ أي يحق له أن يأخذ. He has the right of demanding a guarantor from the transfer's inheritors or debtors, lest the debt be unpayable. Tawa, right? Lest the debt prove unpayable. That's the tawa. Tawa refers to halak, that Zubaydah also disappears. Because the one who originally owed the debt was Zubayr. It was transferred over to Zubaydah. Zubayr fell over the balcony, died. So now Uncle Latif didn't make all this money except by being money smart. So he has a right to seek guarantors from him, because if then Zubaydah proves, because originally the debt belonged to Zubayr. So if Zubaydah couldn't pay, then he can take it from the guarantors of the inheritors. Because the one owed the money has more rights over it than the inheritors. Okay. ولا يرجع عليه المحتال إلا إذا توى حقه. Right? And the one whose debt was transferred cannot be demanded payment, i.e. by the creditor, the one who is owed the money, unless the haqq of حقه من حق الدائن, unless the right of the one owed the money, right? In our case, Uncle Latif, who sold the house, right? Unless his right was at risk of being lost. وَهُوَ بِمَوْتِ الْمُحْتَالِ عَلَيْهِ, which is if the muhtal alayhi, the one whom the debt was transferred to, dies mufallasan, right? With proven bankruptcy. أو إنكاره الحوالة, or the one the debt was transferred to denies the hawala. So then what happens? He can go back to the one he can prove originally owed it. وحلفه, and he denies it and swears in court that I didn't owe the money. ولا بينة عليها, and the one who is owed the money, right? In our case, Uncle Latif has no proof that the one the debt was transferred to owes it, right? So Uncle Latif has a written contract with the original debtor, the original person who owes the money for the house. In our case, Zubayr, correct? But what's the problem? The problem is that we have no documentation of the hawala, right? Because the original contract was taken seriously. He wrote it down, etc. Then Zubaydah stepped in, took on the debt. So what happens? They all agreed, great. But they didn't document it. But once Zubayr died, now Zubaydah is worried for her life and savings. She denies it. And while we hope that everyone has taqwa of Allah, it doesn't always play out that way, sadly. واضح? But so in this case, what happens? If Zubaydah dies, and she left no money behind, or bankrupt, or she denies the hawala, then he can, on the basis of being able to prove the original debt, the one owed the money, the creditor, can go back in these two cases, by the death of the transferee, or the transferee denying and swearing an oath, and there being no evidence of the transfer. So the lesson is, document your transfers. وعندهما بتفليس القاضي إياه أيضا, right? And according to the Sahibain, also if the Qadi deems the person to be bankrupt. Because Abu Hanifa said, legally declaring someone bankrupt is not valid because money comes and goes. But the Sahibain said that no, the Qadi can judge a person to be bankrupt and they are then treated as bankrupt. And that's a separate discussion. And the fatwa would be on what's acted upon. If there's bankruptcy laws, if the person died and they had already been declared bankrupt, then there's nothing demandable. Then the original person, the debt, though it had been transferred, goes back to the person because they originally did owe it. Tamaman. And then he says, وَتَصِحُّ بِالدَّرَاهِمْ الْمُودَعَةِ وَيَبْرَأ الْمُحْتَالَ عَلَيْهِ بِهَلَاكِهَا. So, the kafala is valid, the hawala is valid with dirhams that were given as a safekeeping. Right? So, in these kinds of things, it is very useful to look at مجمع الأنهر, right? So تصح أي الحوالة بالدراهم المودعة. So the author of يعني مجمع الأنهر, he explains يعني لو أودع رجلا 1000 dirham. So one person gives another, right? So Uncle Latif gives Uncle Masir $1,000, 1,000 dirham in safekeeping. وأحال بها عليه آخر, and another transfers that debt to him, it is valid. Right? So the one who has the money in safekeeping, so okay, you owe this, these dirhams that are in your safekeeping, I transfer my debt to so and so to you. And the one who has the money in safekeeping, what does he do? He agreed that, okay, I'll use the money that I have in safekeeping now to pay the debt. Right, so Zubayr owed $100,000 to Uncle Latif. Zubayr had given $100,000 to his wife in safekeeping. So he says, Zubaydah, I transfer my debt to Uncle Latif to you for you to pay. So now his debt is cleared, and in this case, right, al-muhtal alayhi it would not owe the money, right? وَبِالْمَغْصُوبِ وَلَا يَبْرَأْ بِهَلَاكِهَا, right? And the same thing can be done with misappropriate funds, but if they perish, right, nothing is owed. Because in the first case, they're a trust. And then, وَلَوْ قُيَّدَتِ الْحَوَالَةِ بِالدَّيْنِ أو الوديعة أو الغصب لا يطالب المحيل المحتال عليه مع أن المحتال أسوة لغرماء المحيل بعد موته. Right? So if the transfer was specified to be with a debt owed, or with money in safekeeping, or with misappropriated funds, then the muhil cannot demand from the muhal alayhi, right? But in this case, the muhtal, the one who's owed the money, would share in the right of demand. Those who are owed, the ghurama, those who are owed by the debt transfer. So Zubair has a bunch of debts. He said, okay, I'm transferring this money that is owed to so-and-so. It was transferred, so it was made specified with these three things. Or I'm transferring it for that money in safekeeping, then at the time of the death of the مع أن المحتال, in this scenario, the muhtal, who's the muhtal? The one who is owed the money. He would share with the other debtors upon the estate of the muhil, right? The one who transferred the debt to him, right? So there's a number of people who owe the who have rights over the muhil, the one who transferred the debt. So in this case, the muhil would be one of the people who owes, right? So the creditor is counted amongst the debtors upon the muhil's death, assuming, of course, that the muhal alayhi can't pay because it was made conditional, right? وإن لم يقيد بشيء فله المطالبة ولا تبطل الحوالة بأخذه ما على المحيل عليه أو عنده, right? He can still demand, يعني, if the hawala has not been made conditional, right? Has not been specified, not been conditional anything, then he has the right. He has the right of demand. He has the right of demand. Who has the right of demand? Right? Right? If the debt transfer وإن لم تقيد بشيء فله المطالبة, فله أي للمحيل, right? المطالبة, he can demand the debt, if he paid it, ولا تبطل الحوالة بأخذه ما على المحيل ما على المحتال عليه, should say محتال عليه, right? So if he takes that money, right, the right of demand doesn't get lifted from the one the debt was transferred to. So the debt transfer is not cancelled by taking what the transferee owes or what they have, right? Because it ultimately belongs, the right of the debt is owed by the muhtal, the muhtal alayhi. You call it muhil alayhi or muhtal alayhi. تماما. وإذا طالب المحتال عليه المحيل, right? So if the one who the debt was transferred to demands from the muhil, the one who transferred the debt, بمثل ما أحال به, right? If they demand the like of what was owed, فقال أحلت بدين لي عليك لا تقبل بلا حجة, right? So if the transferee demands payment from the transferor, and then the transferor claims that I only transferred the debt to you because you owe me money, this would not be accepted because it's a claim, and the claim requires proof. ولو طالب المحيل المحتال, if the one who transfers the debt demands from the muhtal, the one whom the debt was transferred to, بما أحال, with that which was transferred, فقال أحلتني بدين لي عليك. So he claims that you only accepted the debt transfer because you owe me money, لا تقبل بلا حجة. This too is not accepted without proof, because the general principle that claims require proof. And then the last issue, وتكره السفتجة وهي الإقراض لسقوط خطر الطريق. Right? So this would be a bit like in the old days you had what they called, you guys see, Abdul Latif, you might remember them. They used to have these, what were they called? Traveler's checks. Right? That you would give your money and they would issue you a traveler's check. So you could when you go to another country, rather than carrying like $1,000 on you, you give money to a person So you don't have to carry money. And when you go to the other party, a designated person acting on their behalf would give you the money. And the condition is that, that we're doing this to lift the khatar al-tariq. So now this exactly does not apply in our times in this way. And if it's done just, for example, you do it informally, that look, let me give you $100, let me give you $1,000. I'll take a similar amount from your cousin in Damascus. That's not suftuja, because it's not explicitly giving money to somebody لِسُقُوطِ حَقِّ الطَّرِيقِ, right? So if it's not done explicitly, it's just done informally, then it's not a problem. The issue with suftuja, a traveler's loan to ensure safety, is that the Prophet ﷺ forbade any loan, نهى عن قرض جر نفعا, any loan that derives benefit. What's the benefit that you derive from this? No. Is the haqq al-tariq, right? So it's as if you lent money here and you took money back and you got this material gain of this safe passage, right? But if it's done informally, that, you have an uncle in Pakistan, so you say, uncle, can I give $1,000 to your son over here, and I'll take $1,000 from you when I get to the village? He says, sure, right? This is not a contract, right? Like, it's not structured. When it becomes a structured thing, then that we lend it to you here and we'll give it back to you there, that's where it becomes problematic. This doesn't have too many practical considerations. Remind me, I'll share some discussion on the suftuja. They used to do this on long journeys. People traveling by sea, for example, rather than carrying money with them because pirates would come, they will give the $500,000 here. Once you get to the port in Cairo, they'll give you that money there. So on the way, if you're attacked by pirates, whatever, you don't have money on you, but it was given as a qard. The person who takes the money, what are they doing? During the time you're traveling, they are using that money. And then when you get there, you derive benefit. So it's functionally a qard. You give a loan here to them because the journey may take 6 months. When you get to your destination, you get to Al-Andalus. What happens? You pay, they'll give you the money there. So both parties derive benefit from that loan, right? The loan was given in Cairo. By the time you got to Seville by sea, right? The loan you gave. So this is why it was deemed problematic. When done informally, this would be allowed. There's ways around it as well, right? The contemporary applications we'll see later. And then next we have Kitab al-Qada. We'll begin that بإذن الله تعالى on Wednesday. وبارك الله تعالى فيكم. Any questions we have, we'll take at the beginning of next lesson. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم وآخر دعوانا أن الحمد لله رب العالمين.